according to these records, he could have been prosecuted as an habitual felon.
That is correct, Your Honor.
So he would have been looking at no less than 25 nor more than life imprisonment because of your criminal history. So how y'all were able to fashion a cap of 5 years is pretty amazing with your rich criminal history. 24 CR 1109 is called the State of Texas versus Juan Perez. You were Mr. Perez.
Yes, sir.
Present with Mr. Grover's attorney and the state's attorney. Earlier, you pleaded guilty here in cause number 24 CR 1109 to obstruction or retaliation, a third-degree felony. A pre-sentence report has been prepared. The parties had an opportunity to review it and any corrections or changes to it. State,
None from the state, Your Honor.
defense.
Your Honor, I reviewed this report with Mr. Perez, and we have no changes to make to the report.
It is made a part of the record for all purposes. The agreement is whatever sentence shall not exceed a cap of 5 years in prison. So he is looking at no less than 2 nor more than 5 years confinement in prison. He is eligible for deferred or unadjudicated probation, I believe, as well as regular probation.
I believe
He
that's
could be
correct, Your Honor.
sentenced to no less than 2 to no more than 5 years confinement in prison. That could be suspended and he could be placed on regular probation for up to 10 years. I see the defendant is not eligible for probation according to the indictment from a jury because of a third-degree DWI conviction in 2021 in this court, correct?
That's correct, Your Honor.
Okay,
Yes, sir.
All okay, go ahead. The court's read the pre-sentence report and the defense may go first on allocution.
Your Honor, Mr. Perez would ask the court to basically sentence him to as a small amount of time as possible. Basically, what happened on this occasion was Mr. Perez was out in front of the HEB. He was outside the store, was intoxicated. I think he had a bottle of vodka with him. He threatened the store people, was arrested for resisting arrest from the Beaumont police officers, one of which worked there and then one of which arrived later. And he just he screwed up badly and wishes to ask the court for just to give him a break on this case. Now, he has been to prison before.
How many times?
How many times have you been to prison?
One time was the first time I convicted for 5 years, and one was for violation of parole, and then this last time for DWI.
Yes, sir. He has a burden of habitation from Hidalgo County and DWI, I believe, from Harris County. It may be from this county.
It is from this county.
From this county. And so he has been to prison. He has a number of convictions, but not as many as it might appear. It appears that from Hidalgo County, whatever they had down there mostly disappeared. The records disappeared.
So what we're saying is according to these records, he could have been prosecuted as an habitual felon.
That is correct, Your Honor.
So he would have been looking at no less than 25 nor more than life imprisonment because of your criminal history. So how y'all were able to fashion a cap of 5 years is pretty amazing with your rich criminal history. Plus the fact that the charge is the threatening to commit murder because somebody called the police, which is their absolute right to do in good faith.
Judge, I believe that, and I'm not trying to say that this is nothing or what he did was not wrong, because it was totally. I believe that what the problem was, he was more of a nuisance out in front of the store, and they wanted him to leave because he would keep people away from the store. Now, I'm not denying that he said what they say he said, because if he did, he did, you know, but I don't think that that was his intention. I think that he was he was just drunk there. He said he was recharging his cell phone on the parking lot of the HEB, which it seems more consistent with him ranting, I would say.
The fact is,
Although the court did, I'm not denying that he said what he said.
according to what we have here, this is HEB.
Yes, Your Honor.
Okay, a very important
Yes, sir.
commercial entity here in this town and in others. He was in the front he was begging for money from
Yes.
other people, which is not the right place to do it. I mean,
No.
that's where a lot of people are, but they're, and and he had been ordered not to be there. You weren't supposed to be there in the first place. There was a no trespass order on you that they had gone through the authorities to try to work this out in a peaceful way so that you would not be in trouble. And that wasn't enough for you. And so, go ahead.
Yeah, we don't dispute that, Judge. He had been trespass warned by the store and told not to be there. And again, there's not any way I can say that was what he did was right, but I think that his intent probably was just to get money, which he shouldn't have been begging there, and he shouldn't have been on those premises, more so than the intent to injure anyone.
Okay, what are you asking for?
I'd say, Judge, I'd ask that the court give him a minimum number of time in the Texas Department of Criminal Justice. I don't think that probation would do any good for him because of his being a transient and having this criminal record.
What's they say?
Your Honor, the state would note that the defendant very clearly has a drinking problem. He has several DWI convictions. His last conviction in this court, which happened in 2021, was a felony driving while intoxicated, and the court gave him the minimum amount of years on that, which was 2 years TVCJ. Now, he hasn't worked on his drinking problem at all. He was drunk when this offense occurred. If he's not willing to take probation and go to SafeP and work on his problems, well, then there's no reason for us to give him the minimum in this case. He told the officer that he wanted to kill that staff member, and that he had connections with the mafia and was going to have the complainant killed. And the officer told him to stop making threats, and he said he didn't care about jail time. So obviously, a minimum amount of jail time is not a deterrent for this defendant. We would recommend the max with the cap of 5.
What did you want to say, sir?
Well, sir, I mean, to be honest with you, like, I mean, that report that the officer said that, that I threatened, I've never threatened anybody in my life, to be honest with
So
you.
everybody's lying here.
Well, I mean, what the officer said, I mean, at that point, all I mentioned from that time was that I would be back, and that was because I was charging my phone. I had every intention of
The officer wasn't there. They were told that by the person at one of the staff members of HEB.
No, he told it to the officer,
I
not to the
believe he
staff
told the
member.
officer, the judge, after they had arrived.
All right, exactly. Let's go.
And I'm not sure the pre-sentence report.
I can give you the offense report if you'd like, Your Honor, but he told it to the officers.
Officer Melendez advised while Perez was in his custody, he made statements to HEB staff member who contacted police that he would have them killed for calling the police. Okay. Well, let me read that again. Help me out. Officer Melendez advised while Perez was in his custody, Perez made statements to the HEB staff member who contacted police that he would have them killed for calling the police. I mean, doesn't that say he made a statement to a HEB staff member, the person who contacted the police, that he would have them killed for calling the police? So the only way they would have known that is the HEB person had to have told them that.
Judge, I wasn't there, and so I obviously don't know. And HEB had employed a Beaumont police officer as a second job, and he was on premises, and he was there almost immediately, I believe, Judge. And then, of course, what he did was call for another officer who came, who actually transported Mr. Perez to the jail and all of that stuff. I don't know. Well, I believe we have something from the.
All right, okay. Let's look at Officer Malonsaw. It's Malonsaw.
Yes, Your Honor.
His report.
Yes, sir.
Began to ask Perez if he had an identification on him. I also advised Perez that HEB employees called for police due to him being trespass warned from this location earlier this year. While searching Perez for identification, he began to turn his head and make vague threats to retaliate against the HEB employee that had called the police. I advised Perez to stop talking and that I would not allow him to make threats within my presence. Perez then advised me he didn't give a F word. At this point, I did not want any verbal aggression or threats from Perez to continue, so I grabbed a hold of him by his arms, told him to walk. And once I turned Perez to face south in order to walk him to the back door to the patrol unit, he let the lower half of his body go limp, went dead weight, fell to the ground, and his head struck the concrete, taking me down to a knee as well. And EMS was called. All right.
He also made threats in the EMS, Your Honor, which is that last
He was
paragraph.
transported from HEB, and this is one right on College Street to Baptist Hospital. So,
While on the short ambulance ride, Perez made statements he was going to go back to HEB and have whichever staff member called the police on him killed. Perez also stated that he had connections with the mafia and he was going to have the complainant killed. Perez kept stating that there was a black male at HEB he was going to have killed. But the complainant who filed charges for trespassing was the female manager. So he threatens a lot. He's loose with his threatening remarks. Anyway, go ahead. I think we understand what happens here. He wasn't supposed to be there. He's intoxicated, and his big mouth threatening behavior is getting him in worse trouble than he would have gotten had he just followed the rules, not been there, or followed what the police told him to do, and that was leave. But no, you wanted to make a spectacle out of yourself. You got the attention now.
no.
And these poor people, here's another thing is according to pre-sentence report, you're looking at 25 to life. They should have indicted you as a habitual felon. Any felony offense above a state jail felony, you should be looking at 25 to life. I mean, make something better out of your life instead of being just a drunkard who threatens people. My goodness. But you don't have any wherewithal with your criminal history to be committing crimes. You're held accountable for every crime you commit and your criminal history, which exacerbates the punishment. Okay. But you know that. Now, your lawyer has miraculously limited your exposure to 5 years. When you should be looking, according to history here, a minimum of 25 up to life for making a mess. HEB is one of the leading commercial entities in the city and many other cities, and tons of people are there. I know, I drive by that place, one of them anyway, and they're always packed with people, and making a mess in the front of the stores ruins everybody's life who trying to just go get food. Okay, go ahead, let's go. We gotta move on. You're asking for,
Asking for as low a time as possible, but again, not for probation,
yes, sir.
but for he should receive a final conviction
Okay.
and be sentenced to.
Okay. Finally, Mr. Perez, anything you'd like to say?
Well, sir, to be honest with you, I mean, it's like I said, I mean, all this, I never threatened anybody, but the purpose of all this,
Wait,
I mean,
wait, that-
like I said. I
That's
mean,
not what the
I'm sorry.
police say.
I know it's my word, and that's why I plea bargain, because I know I'm not gonna win. I mean, I know the situation, it looks bad, but I didn't do it. I mean, I didn't.
So you're not
threaten- I
guilty of
didn't
this crime?
threaten.
So
Pardon me, sir?
you're saying you're not guilty of this?
I think what he's saying.
Come on. No, here's what we can do. I'll reject this deal. If you're not going to admit responsibility,
No,
I'll reject it. And then we'll set it on the trial docket and let the state have an opportunity to maybe analyze this case again to determine whether other charges ought to be brought. How about that as an idea?
I'll admit that I'm guilty.
Well, you say you are under oath.
Yes.
According to this plea agreement, you said you are. So I'm saying, don't be telling me you're not guilty of the crime. You're lying one way or the other, but you said under oath you were guilty. Okay, you got to be honest. Start being honest for a change. If nothing further to add, I'm going to find you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You will be given credit for all time you have served in accordance with this case. That is all.
Thank you. Good luck.
Byron,